All right, Senator Leno.
White.
Oh, I'm sorry. All right, Senator Leno.
White.
Oh, I'm sorry, Senator White. Would you like to support your bill?
Wachowski, aye.
All right. So that is 5-1. That bill is out. Senator Monning, this is item 10, SB 253, regarding dependent children.
Thank you, Madam Chair, members. I'd like to begin by accepting the amendments suggested by the committee as outlined in the analysis. SB 253 strengthens the juvenile court process for authorizing psychotropic medication use by foster children. This bill mandates the application of healthcare standards by the judiciary when authorizing psychotropic drugs to children in foster care. No psychotropic drugs would be authorized without prior medical exams of the children, and ongoing monitoring must occur. For treatments with the greatest risk, a second opinion from a psychiatrist must be obtained. The data is very troubling, members. Nearly 1 in 4 foster youth receive powerful psychotropic drugs. Of all the children taking psychotropic medications in California, 52% are given antipsychotics, which have risk factors that can lead to lifelong disabilities, such as tremors, obesity, and diabetes. 48% of foster youth are given antidepressants that have an FDA black box label warning for use by children. We, the state of California, assume the role of the parent for foster youth. It is the job of the legislature to address this problem for a voice that doesn't get heard often. SB 253 seeks to address this issue. Respectfully ask for your aye vote. Madam Chair, with your permission, I have witnesses here in support. I'll ask them to introduce themselves. Thank you.
Madam Chair, I'm ready to move the bill when you are.
All right. Well, let's make it brief. That's a signal that we might get this down. But give us a. Go ahead. Why don't you give us your testimony? 2 minutes, if you could.
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to testify today. My name is D'Angelo Cortillo. Today, I'd like to share my experience while taking medication in the foster care system. I entered foster care when I was 9 years old. During the next 7 years, I was in more than 14 homes, 8 group homes in 4 counties in 3 states. During that time, I was prescribed multiple medications for a variety of diagnoses. As an adolescent, I experienced sexual, mental, and emotional abuse. I was treated like a pet rather than a person. I was hurt and confused and yearned for love and attention. The mental health staff assigned to me said that I needed medication. What I needed was a hug. There are thousands of youth today who are being over-medicated and unnecessarily exposed to harmful chemicals. The most important thing is to give us a voice in this process. Of all the treatments I've received, the most effective for me was equine-assisted therapy. Working with horses did more for me than any drug. There needs to be a place in this process to ensure that youth receive therapy other than drugs. SB 253 is a step in the right direction, as it will require prescribers to detail what therapeutic treatments they are using beyond these powerful drugs and create a higher standard for evidence for courts when considering approving a youth to be medicated. Thank you for your time and your support for SB 253.
And thank you for your testimony. Quickly, any other witnesses? It probably would suffice just to give your name and identification.
Yes, I'm Anna Johnson with the National Center for Youth Law. We're the sponsors of the bill. And thank you. Thank you to Senator Monning for his leadership, and thank you, D'Angelo, for your testimony today. We're in strong support. There are 2 goals in this bill. There are 3 ways that we're trying to address that, and I won't belabor you with those, as I think they were mentioned in both testimonies. Thank you very much.
Madam Chair, I'm Bill Grimm. I'm also with a senior counsel to the National Center for Youth Law. I'm also a member of the state's Quality Improvement Project on psychotropic medication in children in foster care. And we offer our strong support and thank you to Senator Monning for pushing this forward.
Very good. Thank you, sir.
Frank Mecca with the County Welfare Directors Association. We have a support if amended position on the bill. Your committee staff and the prior committee did terrific work on this bill. We're very comfortable with the bill moving forward. We have one last issue to work out. These are our co-sponsors on the Mitchell bill that we brought forward this morning, so this is something that's very important.
Great, thank you.
Nicole Wertelman on behalf of the Alameda County Board of Supervisors, also supporting.
Okay, thank you. Any other witnesses in support? Why don't you just quickly come up here and identify yourself.
Libby Sanchez on behalf of Laborers Local 777 and 792 in support.
Thank you very much. Other witnesses? And is there any opposition to this? All right, go
My
ahead.
name is Rochelle Trottenberg, and I support this bill.
Thank you very much.
Madam Chair,
Yes,
if I may,
certainly, Senator Leno.
when possible, I would like to be added as a co-author.
Thank you.
Very good. All right, any other questions? Senator Monning, would you like to briefly close?
Very briefly, again, I want to thank Madam Chair and your staff for helping improve the bill, and look forward to an aye vote. Thank you.
Motion by Senator Hertzberg. Madam Secretary, this is due pass as amended to Senate appropriations.
Jackson.
Aye.
Jackson, I. Morlock. Anderson. Anderson, I. Hertzberg. Hertzberg, I. Leno.
Aye.
Leno, I. Monning.
Aye.
Monning, I. Wachowski.
All right, that bill has 5 votes. We'll keep it on call for Senator Wachowski. Thank you very much, and thank you for your testimony.
Thank you, Sue.
All right, next we have Senator Leno. He has 2 bills. We'll start with file item 25, SB 682, and then he has file item 27, SB 731. Senator Leno.
Thank you, Madam Chair. Out of respect for time, I'm going to be as succinct as I possibly can. First of all, accepting the suggested amendments in the analysis on pages 9 and 10.
All right, without objection.
So this bill merely requires that courts adhere to similar due process standards as other public entities before privatizing court services. So it does not ban the option, it merely sets some standards. So the bill really is about accountability, transparency, and due diligence. In all sectors of government, California requires that some due diligence standards be satisfied prior to the privatization of public services. However, trial courts, given that they've come from county oversight now to the state, are currently exempt from similar accountability measures. We have drafted this bill to the limitations of Government Code Section 19130 to respond to Governor Brown's veto of Senator Wachowski's earlier efforts. And the bill requires the courts to show that they've used due diligence in deciding to employ a private contractor to perform court services that are currently or have customarily been performed by trial court employees. Specifically, the bill requires the following: a fair cost analysis, proven savings to the taxpayers, competitive bidding, disclosures on the part of the contractor, no displacement of employees, and performance and financial audits. We also have included numerous exemptions to this requirements, including when the service is highly specialized or technical, exempt; when the contract is necessary to avoid conflict of interest, exempt; in emergency situations; and for temporary and occasional services, they're all exempt. So I've got a number of folks here today. I know they will be brief as well. The sponsor of our bill, Michelle Castro with SEIU.
Good evening, Madam Chair and committee members. Michelle Castro, the Service Employees International Union. I will just be very brief. When the courts were part of the county system, as Senator Leno said, they were subject to many of the good government standards exist, but when they moved out of that system to their own system, many did not follow, including whistleblower protections, independent audits, public records, open meetings, et cetera. SEIU and AFSCME over the years have joined with the legislature to reinstate some of those provisions back into the trial courts. This provision is kind of a natural extension of that work. So we think that's important that the trial courts operate much like other government. Finally, we just think it's really never a good idea to associate profits with justice. When you privatize court services, you exchange funds that go to oftentimes wages and benefits for employees, and you exchange them for profit. We just think that's not a good model. We don't think it's a good model in this state. For a lot of other branches of government, we think the same ought to apply here. Thank you.
Thank you. Next witness.
Brian Allison with the American Federation of State, County, and Municipal Employees. I agree with much of what Ms. Castro has already said. I would also like to make a point that trial court employees in this state have been working to try to provide the best possible service to the citizens of the state of California. And they've been doing that under tremendous duress. And I think it's critically important to acknowledge the tremendous work that they've been doing. I think it makes perfect sense to just implement due diligence standards. This bill does not prevent the contracting out. It does not. But what it does do is implement the same due diligence standards, as Mr. Leno has already articulated, that exist in other areas of government. I think that's critically important to understand here. And for those reasons, I encourage you to take a close look at this bill and support it.
Thank you very much. Next witness, very briefly.
Libby Sanchez on behalf of Labor's Local 777 and 792, also the co-sponsors of this measure. Very briefly, I want to highlight to the committee the recent Joint Legislative Audit Committee audit undertaken by the state auditor, which illuminated the abysmal fiscal practices that we've seen in the courts recently, where there have been, a draining of the courts and lots of money being misspent. And something like this just provides a modicum of sunshine and oversight. One really quick example, in one of my courts in Riverside, the court decided, after laying off court clerks who were able to help the public, they decided to instead spend money on a private contract for kiosks. This is in a predominantly Spanish-speaking area, and the kiosk was English-speaking only. Had this bill been implemented, it wouldn't have prohibited the entering into that contract, but it hopefully would have highlighted the point that maybe these things should be thoughtfully thought out. So for those reasons, we're in strong support of this measure.
Right, I'm not sure I would agree that they've been abysmal. They have been a little bit remiss, but with a budget of several billions of dollars, I think that the audit did show that there were some problems, but with all due respect, I think that abysmal is a pretty strong word. It wasn't quite that bad, and maybe it's because I need dinner that I took a little umbrage to that. But certainly there are things that we can do, and I think that the senator has taken significant amendments here, and appreciate you doing that. So anyone else in support? Anyone in opposition? I note that there was late opposition by the courts. That's frustrating as well. So if I'm going to chide one side, I might as well chide the other. We really would appreciate to have the timely opposition so that we can give the authors of these bills the opportunity to engage in meaningful discussions. But given who this author is, I'm sure that he will continue to work with the Judicial Council and note that that they would like to see further amendments. So if you would direct yourselves to additional amendments, the senator has taken 3 that were mentioned by the proponents. Let's focus on those that you would like, and please, again, maybe I'm a frustrated or practice law, and you weren't supposed to file late papers. It does tend to muck up the system a little bit, but we will let you go forward and hope that we can get some resolution to your concerns.
Thank you, Madam Chair. My name is Marcia Slau. I am the chair of
To push your red button. There you go.
Got it?
Thank you.
Good. Marcia Slau, chair of trial court presiding. I need to eat too. I forget what I'm the chair of. Trial Court Presiding Judges Advisory Committee. I'm also the presiding judge of San Bernardino County. Three very quick points. First, I want to thank the author for the amendments. A primary amendment that would be very meaningful to the courts is to make this more akin to the 19130 and make it prospective only.
It is.
Well, if it isn't, it's going to be, because that is the agreed upon position by Senator Leno.
I would then simply ask then very briefly if it could be very affirmative language to indicate that there is a grandfather clause specifically added to it. Second, let me give you 2 very quick examples. We've been asked over and over by the executive branch and the legislative branch to capture efficiencies, and the trial courts have worked very hard to do so. We are concerned that this bill might threaten some of those efficiencies. For example, in San Bernardino County, We work with the Highway Patrol as well as the County Sheriff's Department. They issue all citations through e-citations, as opposed to actually handwriting out citations and then having them driven into the courts for filing and processing. This would mean potentially threaten the e-citation program, and the remote areas such as Needles, where they'd need to drive some 2.5, 3 hours one way to file those citations, would be of detriment to them. Another second example that's very important to me personally, and that is the ability to provide some access of service to the areas where I have had to close courthouses. For example, I customarily hire mediators, family law mediators. I would love to provide, as money is slowly coming back to our courts and making a big difference for us, I would love to be able to provide family law mediators in the Needles area and in our mountains area, which now has no court resources whatsoever, vast areas of our county. I need to hire mediators to do so because, again, I can't send them out on that long drive 2-3 hours away for maybe 1 day of work, 2 days of work. There are many efficiencies that we are concerned might be swept away by this bill without further consideration for amendments. And again, I thank the author for the amendments and ask for some additional consideration, particularly as specific grandfather.
All right, thank you very much. Next witness,
Yes.
please.
My name is Richard Feldstein. I'm the Court Executive Officer of the Napa Superior Court. I'd just like to reinforce Judge Slough's request for an amendment that would truly eliminate any retroactivity. And I'll just give you an example of what it would mean if you don't. Right now, as I see it, that if we had to implement it in a retroactive way, it would cost our court probably $300,000 to $500,000 in additional costs. That being that we get no new revenue because we're a donor court and the restoration of court funds has been very slow. And really what that means, if you do the math, I have to take money from other areas of my budget to fund other services that would be affected by this. And we all know, right now, 70% of my budget goes to my current employees, and this would be the worst time possible because we are working very hard to eliminate a furlough every Friday where we send employees home without a paycheck for those hours. We are working very hard to fulfill a union agreement where we're sitting down, trying to put together money into their paychecks at the end of this year, and also to restore services to our local community. So in essence, if it were to be applied retroactive, it would be robbing Peter to pay Paul, and that Peter would be our current employees. As regard to the necessary standards and good practices, I would just point out that the courts are already subject to the Judicial Branch Contracting Manual as provided by statute from this legislature. We do tremendous amount of reporting, required reporting on all the contracts that we would let for any reason. We also are audited on a regular basis, both by our internal audit team as well as the state auditor, and you may have seen those reports in the past. So we do have good standards already, and this would just simply add another layer that would be onerous to administer and with very little value for the courts and the public we serve. So in summary, I can tell you that there's not a court in this state that doesn't want more employees, but we want to be sure that we can get them into the right place, and we don't want to be restricted and stepping backwards into areas that can be performed better through a contract. We want those new employees to be on the front line providing services to the public.
Thank you. All right, Mr. Jesperson, very quickly, please.
Madam Chair, Corey Jasperson on behalf of the Judicial Council, mainly here for technical assistance. I would note with your prior concern, I personally met with the author's staff on March 27th, provided detailed pages of all of our concerns, as well as a very, very detailed mock-up of our amendments.
Okay, well, I appreciate that, but it's supposed to come to committee as well. I know these are contentious issues. They have been for several years. The good news is we're the first committee on this subject matter this time around rather than the last. I know this author will continue to work with you. You know, hopefully you'll reach an accommodation, but I understand this is contentious, and we are going to, I'm going to recommend we move it forward and allow those discussions to continue. Senator Monning.
Thank you, Madam Chair. Well, I want to thank the author for bringing this forward and being responsive. The goals of access to justice are critical, and our democracy is threatened when we undercut any branch of our government, and we've certainly made massive cuts to the judiciary. That said, those cuts need to be imposed in a way that try to preserve access to justice, keep courtrooms open, and keep employees employed. And I think the motive of this bill is to protect the interest of current employees and make sure they're not replaced or new positions aren't created where they're not given those considerations. I've engaged in all my 4 counties, San Luis Obispo, Monterey, Santa Cruz, Santa Clara, with the courts. They've all brought forth specific examples of concerns. I want to just check with the author because a couple of the examples included Santa Cruz has their traffic tickets processed centrally in Sacramento. Jury summons and jury correspondence is also the subject of existing contracts, and it is my understanding with these amendments, and I'll direct this question to the author, that an existing or current contract or its extension would not be blocked by this bill. Is that accurate?
So as the analysis points out on page 10, on page 2 of the bill, line 4, we are striking the words "or new or extend."
Thank you. And then more broadly, I know some of the specific examples of family court mediators, self-help centers, part-time attorneys who are brought in maybe on a big CEQA case. Again, in our conversation, Senator Leno, you suggested kind of a means test that this bill does not preclude entering into those contracts. It does involve some ongoing dialogue with bargaining units in terms of whether that's the most economical way to.
So given that this is all prospective, it will not interfere with any collective bargaining that goes on at the local level.
And that would be a fair topic for collective bargaining.
It certainly would.
Family law mediators, court attorneys,
again,
et cetera.
The exemptions are, I'm just reading among the dozen of them, the service is highly specialized or technical.
And I know the IT area is another one. And I think, as I understand the distinction there, if there's a one-time need for IT specialization that doesn't warrant a full-time funded position, that would be allowable and subject to that ongoing dialogue with the bargaining unit. If it were to be a full-time prospective position, that would be subject to the terms and conditions of a collective bargaining agreement.
And another one of the exemption is that services cannot be satisfactorily performed by trial court employees. So you just make the case. These are standards, not prohibitions. They're standards. Standards in Government Code Section 19130 that everyone else in state government is abiding by with regard to contracting out.
Thank you. Madam Chair, I know it's late, but I do appreciate the opportunity to just get some of that clarification.
Sure. No, happy to. Happy to.
I want to also thank the employees that serve these courts, the courts, for the services you're providing and your flexibility in trying to craft this to not have some of the feared unintended consequences.
Sure.
So thank you.
And Madam Chair, if I can just briefly close.
Please.
I'm really pleased to hear from the opposition.
Excuse me,
Yes.
Senator Hertzberg had a question. Before you close, why don't you go ahead and ask that question?
Sure.
Court needles. Doesn't the amendment that the author took, it's referred to on page 10 of our analysis, page 4, line 33, this paragraph shall not apply to services contract in order to open a closed courthouse. So if you have these distant areas, doesn't this take this into consideration, the amendment he took?
That, the particular part about opening a courthouse, but what I'm talking about is providing a service, not open a courthouse, such as a self-help center, such as a family law mediator to go up and provide a service, but not actually open up a full-time, full-service courthouse, which we aren't able to do at this stage.
Yeah. And if I could just add, I was the court exec up in Tuolumne County, and it's a very small court. And it's in a very isolated area. And it's not just a branch court. Many of our central courts in those particular types of counties really cannot provide the sorts of services through an employee because of the scarceness of those resources. And so it would be very very limiting in that respect.
Thank you. And Senator Wojciechowski.
I'm glad to see that I'm glad to see we have a good author on this bill now. My my concern is that we want all the courts to do a lot of experimentation. We want them to do restorative justice, and sometimes, since we're not providing money, sometimes they go out and they get grants, and some of these, they're only for like 2 or 3 years. So we want them to do this drug court deal and try new ways to deliver justice. And what I'm just throwing it out there. I don't know where it lands, but if you know it's only going to be for 2 or 3 years, it may be a customary function that's done, but I don't know where that falls as far as court employees when you know it's short term and they can't serve it. So it was brought to me because my PJs have me on speed dial. So
again, one of the exemptions, temporary, urgent, or occasional services.
Madam Chair, could I speak to that briefly?
Very briefly, and then we're going to close.
The exemption for occasional, urgent, temporary would not cover the situation that was brought up, because the operative phrase there is only if the process for hiring a regular trial court employee would frustrate the purpose. So, for instance, if a court wanted to come in and do one-time scan archives, that exemption wouldn't apply, because that's something you would plan ahead for. And as an example, we've requested an amendment that would actually clarify that the delay incumbent in recruiting or the temporary nature of the work doesn't justify a full-time employee.
Then
that's a situation that wouldn't be covered.
My response would just to go back to the standards. You prove that this will be a savings to the taxpayers and no displacement of current employees. Then you proceed.
Okay.
So the close is, number one, I'm pleased to hear that most of the oppositional concern was over the retroactivity. We dealt with that. So that really took away more than half of what was presented in opposition. And beyond that, I would just make the case, second only possibly to you, Madam Chair, I think I've been one of the most steadfast and vocal proponents of funding our court system sufficiently. We're not going to solve the problem of the courts by contracting out. No. That's not the problem here. The problem that we're really addressing is we have cut billions of dollars from this court system, and I'm eager to continue the conversation with the governor, because for some reason, that's where the resistance is. This is not the problem that the courts are really facing, but this is the problem the court employees are facing.
Right. And I know that you will continue. I couldn't agree with you more. We're here to, fighting over fighting over crumbs, and we don't want the court employees to be the pawns here, but at this point in time, unless we get enough money for the courts, we're going to be fighting over every small step of the way. So we're going to invite a continued conversation, and I'm hopeful that in the future we get a little bit more advance notice so we can perhaps help with some of the negotiations. But I want to thank the proponents of the bill for their flexibility, and I want to thank you for your commitment to justice. And if we can get them both together.
Yes, and my commitment to additional thoughtful amendments to the bill.
Good. All right, there's a motion by Senator Hertzberg. This is due pass as amended to Senate Appropriations. Thank you all for your testimony. Please, Madam Secretary, call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson?
Thank you, Judge.
Anderson, no. Hertzberg?
Aye.
Hertzberg, aye. Leno?
Aye.
Leno, aye. Monning? Monning, aye. Wojciechowski?
Aye.
Wojciechowski, aye.
All right, the only two bills left. Thank you all very much. I appreciate this. One more Leno bill. I'm jumping the gun. All right, this is that bill is the bill under consideration is at a vote of 5-1, and it is out. And now we will move to Senator Leno's last bill, which is the last item on the file item 27, SB 731, foster children. Good evening, Senator.
Yes, this bill very simply would require the child welfare workers and caregivers consider a child's gender identity when they're making decisions about the placement of that child into our foster care system. We all know the enormous challenges that our foster youth face, all transgender youth in our foster care system, especially our at higher risk for homelessness and abuse and depression and even suicide. So this is a measure to require some sensitivity when we're placing these children so that they are placed in supportive and encouraging environments rather than the opposite, because it can be very severe. And we had, we were unable for this hearing to have a very successful situation of a foster youth, a transgender man who's now in his 20s. He told the story in the earlier policy committee that he actually was placed in a supportive environment and the benefits it had for him. So we know that it works, and I would ask for your vote.
Thank you. You'll note that there was a motion to motion this. So if we could have it very, very quick.
And there's no opposition to the bill.
And there is no opposition to the bill, as I understand it. Very briefly.
Good evening, Madam Chair and members. I will be very brief. Joe Michael for Equality California. We are proud to co-sponsor this bill along with the National Center for Lesbian Rights and Transgender Law Center. We thank the author for bringing it forward and respectfully urge your aye vote. Thank you.
Very good. Very good.
Frank Beck with the County Welfare Directors. On behalf of the folks who administer the foster care system, we support the bill. It's practical and establishes a state policy that says we're not going to do more harm.
Amen. Thank you.
Good evening, Madam Chair and members. Lexi Howard on behalf of the Juvenile Court Judges of California, a section of the California Judges Association. It's a good bill. We urge your aye vote.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? We have a motion by Senator Hertzberg. Senator Leno, would you like to close?
Your aye vote, please.
All debate having ceased, this is due pass to Senate appropriations. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Anderson, no. Hertzberg? Aye. Hertzberg, aye. Leno?
Aye.
Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye.
That is 5-1. That bill is out.